Hi, good afternoon, everybody. So, today's lecture, we are continuing with the specific leaf act. And in last, yes, which section we covered? So, open up your bare apps. So, we were doing section 17 of specific leaf act. So, this is in continuation of the earlier lectures which we have conducted. So, section 17 of specific relief act. So, read section 17 of specific relief act.
Contract to sell of that property by one who has no title nor specifically enforceable. Number one, a contract to sell or let any immovable property cannot be specifically enforced in favor of a vendor or lessor. Subclause A, who knowing to have any title to the property has contracted to sell or let the property. Number B, who through he entered into the contract believing that he had a good title to the property, cannot at the time fixed by the parties or by the court for the completion of the sale or letting, give the purchaser or lessee a title free from reasonable doubt. Second point, the provisions of the subsection 1 shall also apply as far as may be to the contracts for the sale or hire of the immovable.
Yes. So when I talk about section 17 of specific leaf act, the heading says contract to sell or let out property by one who has no title, not specifically enforceable. In my previous lecture, also I have told you that whoever sells the property, the title has to be clear. Because when we will be discussing Transfer Property Act, there will be a head of sale. So always remember, title means when I talk about title, I talk about the ownership. Okay, na? So if the title is clear, then absolutely that person has a right to sell a property. For example, A wants to sell his property. My question to you is, can he sell the property if his property is already mortgaged with the bank? No. So answer is, why no? Because title is not clear. There will be no buyer in this world who will want to, title has to be clear. So if already the property is mortgaged, you cannot sell the property without getting a NOC. And which buyer in the world will buy a mortgage property? Eventually, that property means, yes. So eventually, that property means that the property has to be free from encumbrances. So when we do sale deed, when we, when we will, when like sale deed is there, so you will see sale deed has its own, there are set paragraphs, what I call covenants in law terminology. So whenever I assume that you have seen sale deed, but whenever you have, by chance you happen to read a sale deed, normally you will see there is a consideration amount because sale without consideration is no sale. So the amount will be recorded. Okay. Then it will be recorded, the seller and buyer, obviously the party's name will be recorded in that. You know? Then obviously the most important point, which will be the part of the sale deed, will be the property is free from encumbrances. Meaning by it is absolutely a clear title. Neither it is mortgage, neither it is, you see, acquired by the government. So always remember, whenever you as a buyer buy a property, you have to be sure that the title is clear. Now, a lot of frauds take place and a lot of litigation take place in these cases. Reason being that normally people, here also the whole thing is your senses. This is what I say when you talk about principle of evidence in civil cases. Now here I am talking about the principle of evidence in civil cases. That is preponderance of probability, right? So when I talk about preponderance of probability, it means what an ordinary person would have done in that situation. Suppose you are a buyer. You cannot just close your eyes and trust a seller that no, whatever he's saying, it's truth. No. We have right of buyers and right of sellers when we discuss transfer property. Okay? So whoever buys the property, he has to be vigilant. There has to be due diligence. How? देखो, suppose करो, you want to buy a property in Chandigarh. Okay? So Chandigarh, first you should remember it is a union territory. So Chandigarh, we have properties. Let us say there is a residential property or a commercial property. So suppose karo, we are sitting in this building today in Sector 15. This is a commercial building. Okay? Now, if somebody wants to buy this property, he has to do investigation on his own. Now, see in UK or in USA, this part is done by the solicitors. And here also, if you ask me, it is always advisable to get the core information that whatever is the record of this property. Now, record of the property is with the municipal council. Chandigarh, we have municipal corporation. Okay? Punjab, Haryana, wherever you see, suppose the properties in Ludhiana, there will be Greater Ludhiana Development Authority. है ना? In Mohali, you call it Greater Mohali Urban Development Authority. Amritsar the le lo. Same with Panchkula, you have Hudda Haryana Urban Development Authority. है ना? So these are the forums of the government where all the record of the property is there. Because you see, even when you mortgage a property to a bank, mortgage matlab गिरवी, bank never takes your property just because you want a loan. First of all, you have to satisfy the conditions. What conditions? That whether you have a paying capacity to pay back the loan. है ना? Then they appoint a lawyer or a person who's working in the, like in that fora, they appoint a lawyer and they ask for a legal. Now, I have taken loan. In my property also, there was a lawyer who went to the state office in Chandigarh and who searched the property and who, who recorded everything when this property was allotted. I am a subsequent buyer in this commercial building, right? So, who was the previous owner? Whether there were any kind of, illegalities in the building, कोई building violation तो नहीं हुई. Some cases not pending in the court. So all this has to be seen. Only then you buy a, because at the end of the day it is your hard-earned money. बच्चे? At the end of the day it is your hard-earned money which is put, and everybody wants to buy a house. Roti kapda makan, I always say. So that is why these aspects are very important for you to understand, that you have to be vigilant enough. So this is what, when these things, you're supposed to know. Even, in Transfer Property Act, when I'll be elaborating on TPA, especially the head of sales, you will see there are rights of buyers, the right of sellers. You know? So this is what Section 17 says. Nobody can sell a property whose title is not clear. Okay? Vis-a-vis, it also talks about the lease. Now, I told you different heads of Transfer Property Act: sale, lease, gift, mortgage. So lease is also one of the important heads of Transfer Property Act. So lease also, matlab, now this building, now this is a commercial building, right? Now I'm sitting on this floor and this is rented to a academy, है ना? Nimbus Academy, and this part is with me. So in my rent deed, I have rented this out. So obviously, if I am the owner of the property, only then I can rent this, na? And it has to be clear. Now, if I am not a owner, this is a disputed question, then how can I lease it out? Same applies in rent matter. So that you can only rent a property if you are in a legal capacity to rent it out. So this is basically the summary of section 17. So it says, yes, uh, yes. RMN, just read 17A, section 17 once again. Yes. Yes, Bhavna, read section 17A once again. So section 17(1), a contract to sell or let any immovable property cannot be specifically enforced in favor of a vendor or lessor. So two parties are there in sale, vendor and vendee, and in lease, the lessor and lessee, who, knowing not to have any title to the property, has contracted to sell or let the property. Clear? This I have elaborated. Second clause B says, who, though he entered into the contract, believing that he had a good title to the property, cannot at the time fixed by the parties or by the court for the completion of the sale or letting, give the purchaser or lessee a title free from reasonable doubt. So person who cannot deliver a title, because you see, time fixed by the parties. Dekho, when sale deed is also there, sale deed has to be in front of a registrar. Now sale has to be registered, right? You cannot say that sale can be under. It is a registered document. You have to pay the stamp duty on it. Normally it is 7 to 8% of the total value of the property, and it has to be registered because since Transfer Property Act was written long time back, there is one thing: if property is more than rupees 100 or more, tell me in today's time, do you get anything of 100 rupees? Nothing. So sale deed has to be registered. So suppose karo, the party has fixed a date. Now let us say 13th of February is the date of sale deed. Now on that day, obviously it has to be registered. Where will it be registered? You have to go to the executive court, executive magistrate. When you do jurisdiction of the courts, executive magistrates are there. कौन होते हैं सर? तहसीलदार होंगे ना, कौन है? PCS officers, that is Punjab civil servants, Haryana civil servants. In Chandigarh ਦੇ ਵਿੱਚ we have few HCS officers, few PCS officers. So there are different तहसीलदार्स. So तहसीलदार is called sub divisional magistrate also, है ना? ਉਹਦੇ ਅੱਗੇ ਜਾਓਗੇ ਤੁਸੀਂ, then he will call the parties, photograph click ਹੋਏਗੀ, witnesses ਹੋਣਗੇ, ਤਾਂ ਜਾ ਕੇ ਉਹ ਪਹਿਲਾਂ he has to be satisfied, sir ਆ ਦੇਖੋ, first you have to take an online appointment. ਇਹ ਤਾਂ ਹੈ ਨਹੀਂ ਸਿੱਧਾ ਜਾ ਕੇ ਰਜਿਸਟਰੀ ਕਰਾ ਲਓ, ਠੀਕ ਹੈ ਨਾ? So ਅੱਜ ਕੱਲ it is online appointment here. So ਉਸ day के अंदर both the parties to be present. Suppose करो the other party is not present, then how can the sale lead? हो सकती है sale lead? नहीं हो सकती ना. Similarly, in lease, now in lease also I tell you, lease the law है कि lease deed means the rent deed. Lease deed, if it is of 11 months, then there is no requirement of the law to register it. But it is more than that, then it has to be registered. And my advice to everybody, it is better to revise to have a registered lease deed, because oral lease deed fair problem हो जाती है, oral agreements to be proved in the court. So normally, if it is a lease deed less than 11 months, then you can renew it on 11-month basis, but it doesn't require registration. If it is more than 11 months, then registration. So basically, this is the, it is all contained in section 70. So moving forward, yes, am I clear to everybody? Those who are online also? Okay. Now we move to section. So we have done 14, 11 to section 14. We have done section 16 also, right? Now let us come to. Now let us do, yeah. So let's open up the data now. So let us come to section 18. But a specific relief act amendment, specific relief act 2018, section 18. Okay. So let us read section 18. Yes. Read section 18, beta. You read now.
Law enforcement accepts with variation. Where a plaintiff seeks specific performance of a contract in writing, to which the defendant sets up a variation, the plaintiff cannot be obtained the performance sought, except with the variation so to set up in the following cases, namely, number one, whereby fraud, mistake of fact, or misrepresentation, the written contract of which performance is sought in its terms or effect different from what the parties agreed to, or does not contain all the terms agreed to between the parties on the basis of which the defendant entered into the contract. Second, where the object of the parties was to produce a certain legal result which the contract as framed is not calculated to produce. Third, where the parties have subsequently to the execution of the contract varied its terms.
Yes. So basically, section 18, when you read, so it talks about the variation now, right? So when I talk about the variation means, there is a defect or some kind of insufficiency in the written documents arising out of the contract, right? So when I talk about these sections, I'll just elaborate on some kind of a, so let us take an illustration, right? So let us suppose that A sues B to compel specific performance of contract in writing. So this is a written contract to buy a dwelling house. Dwelling house means where he can live, that is a residential house. Right? Now B assumes that the buyer wants a house along with the courtyard. Okay. So the courtyard means can be, you all understand what courtyard is. So B proves that, so he assumes that that the buyer wants a house with the courtyard and he tries to prove it also. Okay. So now here the court now, so here, court cannot force this contract to be, go ahead unless or until this variation is settled, right? Why? Because see, he can always say, "जनाब मैं तो सिर्फ घर लभ रहा सी," ठीक है ना, buyer, and the agent can say, "No, I assume Gigi, you wanted to buy a house with a courtyard." So this kind of a variation, then this section talks about that here. Now it says where a plaintiff seeks specific performance of contract in writing, to which the defendant sets up a variation, the plaintiff cannot obtain the performance sought. So obviously, if suppose that plaintiff has filed a case, right? He says that I want a specific contract, to be performed, and the defendant proves in this that no, sir, he wanted to buy a house with the courtyard. Then court cannot order for that specific. It is quite understood, right? This variation is there. So these are the circumstances. Now, these variations can be because of few factors. Fraud, okay? These are the elements of contract we have done, that any agreement has to be free from, fraud, undue influence, misrepresentation, mistake, right? Then we talk about mistake of fact. Now, when I talk about mistake of fact, again, when I always told you from day one that mistake of law is no excuse, right? But where a mistake of fact is there, then these are the circumstances of variation, right? And then it says or misrepresentation, right? So here, but so these are the terms which variation takes place, and these are, these have to be sorted among the parties, right? So if the variation has been agreed afterwards, so that only can be enforced to the courts, right? So if the court cannot enforce a specific performance of these kinds of particular contracts. Clear? Moving further, Now here, yeah, I can give you one of the case laws also of Supreme Court. That is, write down the case law. I'll give you the citation. K. Narendra. K. Narendra versus Raveria Apartments. Now, this is a 1999 Supreme Court case. Now, moving further, we talk about part performance of contract. Now, let us go back to section 12. So, we talk about now part performance of the contract. So, let us come to section 12. Specific performance of a part of contract. Yeah. So, let us read section 12. Yes, Bhavna, read section 12. Or Akshay can read section 12. Achha. Who has a mic or anyone can read? RMN, can you read section 12? Bhavna, you're not audible? Yes. You guys are not audible. Okay. Let me. Okay. I think, let me go through it. All right. Participants. All right. Bhavna, now you can talk. Audible. Now, Bhavna, can you hear me? Can you just uh, read section 12? You have to unmute yourself. Reading, but I can't hear you. Yes. Okay. Yes. I can hear some mic voice. Can you read section 12? Yeah. Yes, Bhavna. Specific performance of a contract. Yes, you read.
Section 12, specific performance of part of contract. Number 1, except as otherwise hereinafter provided in this section, the court shall not direct the specific performance of the part of the contract. Second, where a party to a
So it
contract.
means that specific so whenever I talk about relief of specific performance provides that person should get relief in specific. That is whole of the relief he is been asking for. You cannot give in parts. Now the exceptions are here in section 12 that we'll read further. Yes, carry on.
Second, where a party to a contract is unable to perform the whole of its part of it, but the part which must be left unperformed by only a small proportion to the whole in value and admits of compensation in money, the court may, at the suit of either party, direct the specific performance of much of the contract as can be performed and award compensation in the money of the deficiency. Third, we are a party to.
Yes. So first exception now, whenever you read section 12, see the first word written is except as otherwise hereinafter provided. So you all have read interpretation of statutes. इसका मतलब ये है कि except these are the exceptions as otherwise hereinafter provided. मतलब the general rule is the specific performance has to be in whole. It has to be provided. It has to be a whole contract. You can't pick, small parts and say, "Nee, this part is can be specific performance performed, other can be just, that doesn't need specific performance." No, specific performance has to be in totality. But exceptions are there. What exceptions? They are only mentioned in section 12. First exception, just our fellow associate has read, where it says, now the first exception means where unperformed part has been bears a small proportion to the whole of the contract. So, yes, we were reading completed where again read section 12 to where a party.
Where a party to a contract is unable to perform the whole of this part of it, but the part which must be left unperformed by a only small proportion to the whole in value and admits of compensation in money, the court may, at the suit of either party, direct the specific performance of so much of the contract as can be performed and award compensation in money for the depreciation.
Yes. So first exception is very clear, if a defaulting party is unable to perform a small part of the contract, right? And that only bears a small proportion. In that case, is the see, I have told you, general remedy is the damages, and the specific remedy is the specific contract, right? So for that small part, if the compensation can be given and in money, then court may, again, it is the discretion of the court at the suit or either of the parties direct the specific performance of the party. Okay? So here you should always remember that court shall reduce the price of the unperformed part and will also give the damages for the un. Okay? Clear? This is very important. That court shall reduce the price of the unperformed part and will also give the damages for the unperformed. Right? So these are very, very important aspects which we should understand. So uh, let's move forward. We read section 12 to 3 now.
Third point, we are a party to a
Slowly, slowly, read slowly.
where a party to a contract in is unable to perform the whole of its part, the party which must be left unperformed either, subclause 1, forms a considerable part of the whole through admitting of compensation in money, or second, does not admit of compensation in money. He is not entitled to obtain a decree for specific performance, but the court may, at the suit of the other party, direct the party in default to perform specifically so much of his part of the contract as he can perform if the other party, subclause 1, in a case.
So let us first, yeah, sir, subclause B1, yeah, read it.
In a case falling under clause A, pays or has paid the agreed consideration for the whole of the contract reduced by the consideration for the part.
Let us first discuss 12 3A, right? Again, read 12.3a. It says, where a party to a contract is unable to perform the whole of his part of it, and the part which must be left unperformed either forms a considerable part of the whole, though admitting of compensation in money. So here, if this clause, whether is clause 12 to is different, there we were only talking about the part which was very, very minute, which was, which was a very small proportion was to be completed. Rest of the part was, there was no problem in granting specific performance of the contract. But when I talk about this clause 3, 12 subsection 3 clause A, so it has two conditions. It says must be left unformed. So first, the unformed part has to be the considerable part, right? And it does not, the second, or it says, does not admit compensation. So it means here we talk about where unfound part bears a considerable proportion to the whole of the contract. So when you see consideration part is the major part of the contract, then specific performance of the part of the contract has to be on the following condition, right? First, he says he has to pay agreed consideration for the whole of the contract. after deducting the consideration for the unperformed. So the other party has to pay whatever the agreed consideration is between the parties. Suppose the other party says, yeah, I'm unable to give this, I cannot perform this specifically. So then you have the right to tell him, okay, you gave me compensation of this amount, whatever amount. Hypothetically, you give me compensation of this much lakhs or whatever the amount has been there. And if the other party agrees, then there should be no problem, right? This is much written here. So, but when you take that compensation, you will obviously deduct the compensation which has been reduced, right? You have to deduct the compensation which has already been performed, the minor part. Let us say in this case, since the major part is unperformed, the minor part is performed, then obviously you will deduct that amount from the compensation which you are given. Clear? Now let us come to second subsection. So it says he has to relinquish all his claims, including. So these are the conditions. First condition is that you agree to the compensation and you will minus the amount of the compensation which of the part which he has already performed. That is a minor part. Second condition says he has to relinquish all his claims, including right of compensation for any deficiency or loss incurred on account of the default of the other party. So he has to relinquish all his claims. Now, once you have taken the compensation, okay, then you also have to have this condition that relinquishment of his claims, including right of compensation for any deficiency or loss incurred on account of the default of defaulting party. So that is also one of the conditions which have to be taken care of. Now let us read section 12.3. Yeah. Read section 12.3. Where a party
Where a party to a contract is unable
12.3b. We have done 12.3a, now 12.3b.
does not admit of compensation in money, he is not entitled to obtain a decree for specific performance, but the court may, after the suit of other party, direct the party in default to perform specifically so much of his part of the contract as he can perform if the other party,
Yes.
subclause 1, in a case falling under subclause A, pays or has paid the agreed consideration for the whole of the contract, reduced by the consideration for the part which must be left unperformed, and in a case falling under clause B, the consideration for the whole of the contract without any abatement. And second, in either case, relinquish all the claims of the performance of the remaining part of the contract and all right to compensation either for the deficiency or for the loss or damage sustained by him through the default of the defendant.
Yes. Next 12.4.
12.4. When a part of the contract which taken by itself can and ought to be specifically performed stand on a separate and independent footing from another part of the same contract which cannot or ought not be specifically performed, the court may direct specific performance of the former part. Explanation. For the purposes of this section, a party to a contract shall be deemed to be unable to perform the whole of its part of if a portion of this subject matter existing at the date of the contract has ceased to exist at the time of its performance.
Now let us now first discuss 12.3b. So whenever I talk about 12.3b, you have to understand the following conditions. The first condition should be a plaintiff. Now it says a plaintiff pays the entire consideration of the contract without any reduction or abatement of unperformed contract. This is written in the last few lines. This is the first condition. Second condition, it says in either cases. So I'm talking about either cases, both clause A and B. I have discussed earlier also that in clause B also, he has to relinquish all his claims including the right of compensation for the deficiency or the loss or damage sustained through the default of the defendant. So he has to relinquish it. So now moving further, we have section 12 clause 4. So section 12 clause 4 says where a part of the contract is enforceable and severable from the unperformed part and it stands on a separate and independent footing, the part of the contract which is capable of performance can be specifically enforced. Now here, whenever I read section 12 clause 4, you will always read this with section 56 of the Indian Contract. So write 12.4 read with section 56 of the Indian. Because section 56 include the cases where within the ambit of unable to perform. So unable to perform include cases, for example, because of the inability. Now that can be deficiency in the quantity. You can write it down, deficiency in the quantity or subject matter. There can be variance in quality. There can be defect in title. There can be some legal prohibition, write down defect in title. So suppose A wants to buy a house of B. Huh? So when we talk about, let us say that before buying the house, cycling comes and the house is destroyed, right? So you cannot, so this is a contract of impossibility of performance. So then obviously the purchase money has to be returned back. So this is one of the classic examples you should remember this. Now moving further, we talk about section 30. So let us read section 13. So section 13 basically talks about the right of purchaser or lessee against person with no title of imperfect title. You remember we have done section 17, which talked about imperfect title or no title. So section 17 has to be read with section 30 because it talks about the rights. What are the rights of the purchaser or lessee against the person who has no title to the property? Obviously, he has the rights. Na? जिन्होंने ठगी मारी है, तो the people who are there, they also have some rights. Huh? So read section 13. Read section 13 on your own, and then we discuss. So first talk about section 13A, yeah? Clause 13A. So read 13A. It says if the vendor or lessor has subsequently to the contract acquired any interest in the property, comma, the purchaser or lessee may compel him to make good the contract out of such. Huh? This is it. So the best example is suppose there is a property of A, okay, and A is basically property of A is there, and B projects that this property is mine, and he tries to sell it to C. But in reality, it is a self-acquired property. So B projected that it will come to me, or whatever, by any way, by way of, will or something, he projects ki, हाँ भी this property is mine. Eventually, it will come to me, and I am the owner. Now, suppose buyer comes to know he is not the real owner. Meanwhile, A dies, and there is a will in name in favor of B. So, will come into picture only when the person is no more. Okay, na? So, in this case, since A has died and the will was in favor of B, now eventually who's the owner? B is the owner. So now C can compel B कि नहीं, now you are the owner, now you transfer. So again, it is the discretion of the court because it is written may compel, है ना? May compel him to make good the contract out of such interest. So this is the remedy with the purchaser. Earlier you were not the owner, now you are the owner, and he can compel, may compel. So again, it's the discretion of the person. He may compel. So here, if it is the case, you can claim that remedy. These are the rights of the purchaser or lessee. Clear on this?
Yes.
Now we talk about clause D. Read section 13B. So it says when the concurrence of other person is necessary. Matlab, when what is concurrence? Concurrence means if your interest is also dependent on, now we say it's a joint property. Joint property has multiple owners. In agriculture property, normally you see there is a joint property A, B, C, and there is a rule of property. Each and every co-partner is owner of each and every part of the land, unless or until it is partitioned. This is the common rule. You all should be aware. So if it is a joint property, na, the co-owner has the same rights. Each and every co-owner, joint owner has the same right in the property. ठीक है ना? Everybody, nobody can say this part of the agriculture property is mine. ये जो fertile land है ये मेरी है, जो बंजर land है ये मेरे उसकी है ना. Each and every joint owner is owner of each and every part and parcel of the land. जब तक partition नहीं होती, nobody can say कि this is my special, right? Now suppose it says about concurrence. Concurrence, the best example I can say is that suppose there is a joint property, है ना? And somebody projects कि this is my property, है ना? And suppose the buyer is buying that property. So eventually, if the one of the joint owners, suppose there are two joint owners, है ना? So suppose if the buyer comes to know कि नहीं, they are he has a power of attorney on the basis of the other joint owner, and he gives his assent, then obviously the buyer can force the one of the joint owners, okay, since you have got the power of attorney of other brother also, so you can sell the property, you can compel them to sell the property. There should be no reason. Okay? Now let us read section 13C. Now this talks about the mortgage, right? So mortgage is another important topic of transfer property. Mortgage means girvi rakhna. Mortgage means girvi rakhna. So whenever we talk about mortgage properties, there are different kind of mortgages. In Transfer Property Act, I will tell you there is English mortgage, there is a simple mortgage, there is a usufructuary mortgage, mortgage by deposit of title deeds, like banks we have a title deed. So there are different kind of mortgages. So this preposition is also very clear. It says where a vendor professes to sell. Now, who's a vendor? Vendor means the seller. So I told you in the beginning, the property has to be free from encumbrances. Encumbrance मतलब होता है कि now mortgaged है, now loan पे है, now gift मतलब कि neither it is on loan, neither it is with the bank. It is absolutely title. But this clause talks about those properties which are unencumbered, means which is already there having some title is in, suppose it is mortgage. Now, this particular clause C talks about that where the vendor professes to sell unencumbered property, but the property is mortgaged for an amount not exceeding the purchase money, and the vendor has in fact only a right to redeem it. The purchaser may compel him to redeem the mortgage and to obtain a valid discharge, and where necessary, also a conveyance from the mortgage. So it means कि किसी ने property गिरवी रखी हुई है, then and if that property, the the mortgage amount is not more than the purchase money. लिखा हुआ है ना? If it is not exceeding the purchase money, that is the consideration amount, then vendor has in fact only a right to redeem. So usko, obviously he has only right to redeem the property and to obtain a valid discharge. So suppose karo, you buy a property which was already mortgaged, na? You can always compel that person to pay out जाके गिरवी property को. So how you redeem a property? There are two things in mortgage. One is foreclosure, one is redemption. Redemption means when you pay the money back and and then you get your property documents from him and it is mortgage free. So when you talk about mortgage, you make sure in these cases the if the purchase money is there with him and he can, then he is bound to get the property redeemed from the original, you see, mortgagee, and then he has to convey it to the new purchaser. हाँ जी यार देखो मैं प्रॉपर्टी गिरवी रखी थी मैंने उसको पैसे दे दिए and this is now free from mortgage. Now this is your, this is one of the rights of the rights of the subsequent vendor. Subsequent vendor दी गल हुई ना. Subsequent vendor means कि obviously original seller था इसके बाद उसने बाय कर ली उसकी mortgage की property. Subsequent vendor का right है कि उसको बोलेगी तो उसको mortgage free कराए. Clear? So all these sections which I am reading, we will have more understanding when we discuss Transfer Property Act. Okay. Now we read section 12D, 13D, sorry, on your own. Yes. Very easy. I don't think I need to elaborate on this. So it says, where the vendor or lessee sues for specific performance of the contract and the suit is dismissed on the ground of his want of title or imperfect title. So the defendant has a right to a return of his deposit. Yes or no? The seller ਨੂੰ ਪੈਸੇ देते, seller is not able to prove his title. He is bound to give you back your money. Earnest money तो वापस देगा ना? Yes or no? Not only earnest money, also the interest therein. This is what it is written. To return his deposit, if any, with interest thereon. To his cost of the suit, even the litigation expenses will be there. And to a lien for such deposit, interest and cost on the interest, if any, of the vendor or lessor in the property which is subject matter. So these are the important rights and rights of purchaser or lessee against a person with no title of imperfect title. Now let us come to section 15. We have already done section 14. And it was exception where specific performance of contract cannot be granted. Section 11 to section 14 and section 16 we have done. Now we come to straight away to section 15. That's what says section 15 says. Very important section. Who may obtain specific performance? Persons for or against whom contract may be specifically enforced. So let us read now section 15. We'll have yeah, I think section 15. Okay. Wanted to have a break for 5 minutes, huh? So we can have a break for 5 minutes, all of you. So we have a break for 5 minutes and then we resume. Okay? Okay. Okay. Yeah. So now, am I audible?
Yes, sir.
Yeah. Am I audible, Bhavna? Okay. Right. So now we could talk about section 15. Huh? So section 15 is very, very important. I have told you. Now in section 15, you should always remember there was amendment in 2018 where they have added the limited liability partnership. It was not there. Rest of the section is almost same. So let us now read section 15. So when we talk about section 15, we talk about who may obtain specific performance. So it says, except otherwise provided by this chapter, the specific performance may be obtained by any party thereto. Second, it says the representative in interest or the principal of any party thereto, provided that where the learning, skill, solvency, or any personal, just read uh, clause B. Yeah.
Clause B. The representative in interest or the principal of any party thereto, provided that where the learning, skill, solvency, or any personal quality of such party is a material ingredient in the contract, or where the contract provides that his interest shall not be assigned, his representative in interest or his principal shall not be entitled to the specific performance of the contract unless such party has already performed his part of the contract or the performance thereof by the representative in interest or his principal has been accepted by the other party.
Yes. C.
Where the contract is a settlement on marriage or a compromise of the doubtful rights between members of the same family, any person beneficially entitled thereunder. Subclause G, where the contract has been entered into by a tenant for life in due exercise of a power, the remainder man.
The remainder man. So remainder man means a person who holds or is write down a person who holds or is entitled to receive a remainder. Now, what is remainder? Remainder means a future interest. What is remainder? Remainder means a future interest arising in a third person, which may be vested, or it is conditionally contingent, depending upon the im- language employed in the document. For instance, example is if a grant is to A for life and then to B, then B's future interest is a remainder. So this is one of the examples you can know. Yes, read further.
Subclause D, where the contract has been entered into by a tenant for life in due exercise of the power to reminder. And subclause E, a revisioner in possession where the agreement is a covenant entered.
A reversioner is in possession where the agreement is a covenant entered into within his predecessor in title and the reversioner is entitled to the benefit of such covenant. So covenants, I have told you earlier, covenants basically means all these sale deeds, rent deeds, lease deeds, or mortgage deeds, all whatever the language is there, it is called a covenant, right? So reversioner in possession, where the agreement is a covenant entered into with his predecessor in title, and the reversioner is entitled to the benefit of such covenant. Yes, next.
Subclause F, a revisioner in reminder where the agreement in such a covenant, the revisioner is entitled to the benefit thereof and will sustain material injury.
Sustain material injury by reason of its breach. Then we have FA. Now, FA is the one which has been amended in 2008. Yeah? So, write FA there, FA in the Bear Act also. F के बाद FA लिख दो, amendment लिख दो. So, FA basically talks about when a limited liability partnership. So, what is a limited liability partnership now? This you should remember. So, when I talk about limited liability partnership, this is also one of the new enactments. This is also one of the new acts of 2008. So limited partnership is defined in section 2 of Limited Partnership Act of 2008. So it says section 2O says, right, so basically it means, so it defines limited liability partnership to mean a partnership firm and registered under this act. Section 2O of the act defines limited partnership agreement as any written agreement between the partners of the limited liability partnership or between the limited liability partnership and its partners, which determines the mutual rights and duties of the partners and their rights and duties in relation to that limited liability partnership. Clause Q further states that partner in relation to a limited liability partnership means any person who becomes a partner in the LLP in accordance with the LLP agreement. Section 3 stipulates the following features of a limited partnership.